Welcome to Nyay Pathshala. In today's session, we embark on a journey into the intricacies of the world of trial strategies, and with particular focus on a crucial aspect of evidence law, that is section 145 of the Evidence Act. Contradiction is an important tool in the hands of a defense lawyer, and it has to be effectively used during cross-examination of any prosecution witness. Likewise, omission is also sometimes treated as a contradiction. So before we go into the niceties of the legal provisions in regard to contradictions and omissions which may amount to contradiction, we have to first look into section 145 of the Evidence Act. And section 145 of the Evidence Act is a powerful tool in the hands of lawyers which enables them to dissect inconsistency and also to unveil the truth. So let us examine what is contradiction and when can an omission amount to a contradiction and how it can be proved during the trial. Let us first understand the simple meaning of contradiction as per dictionary. The dictionary defines contradiction as the act of saying something that is opposite or very different in meaning to something else what is said earlier. So for the Evidence Act is concerned, the word contradiction is not defined under the Evidence Act or under the Code of Criminal Procedure. So in a case, if a witness testifies before the court that a certain fact exists without stating the same before the police, then it is a case of conflict between the testimony before the court and statement made before the police. This is contradiction. Therefore, statement before the police can be used to contradict his testimony before the court. A makes certain statement before the police, and he makes a statement during trial in the court which is not in consonance with the statement made before the police. So this is contradiction. So as we progress during this lecture, we will also discuss how contradiction has to be proved to be admissible in court. So in trial, while cross-examination, a contradiction happens when a witness under oath says something that is opposite or very different in the meaning or otherwise to what is mentioned in the previous statement recorded. The prosecution witnesses are stated in the charge sheet. They come to depose before the court. When they first depose to the court, then we call them, their statement we call it a examination in chief. Then the defense is given the opportunity to cross-examination those witnesses. So remember that something which is said in the 161 statement, that is the statement recorded by the police during investigation, and something which is said different during the trial, then that is contradiction. Now let us examine the dictionary meaning of omission. Omission is something that has been left out or excluded. And during trials, while cross-examination is going on, an omission takes place. And when does it take place? When the witness purposefully, kindly remember, an omission takes place when the witness purposefully or otherwise he misses out or omits any fact or statement he has made in his or her statement recorded earlier. That is the statement which he gave it to the police. So kindly remember that omission and contradiction both relate to previous statements made by a witness, most commonly under section 161 of the CRPC. And if you look it in a more simpler language, omission means missing to state something from the earlier statement. It can be also said that causes and more particular effects of such something missing, that which you call omission, and something different, which we call contradiction, have to be dealt by the trial court judge while weighing and appreciating the testimony of the witnesses. But a reference at this stage must be made to section 155 of the Evidence Act, particularly section 155 subsection 3, which reads, by proof of former statements inconsistent with any part of his evidence which is liable to be contradicted. So when you study, when you want to know more about contradiction, kindly look at section 155 of the Evidence Act as well as section 157 of the Evidence Act. And section 157 of the Evidence Act says that the former statement of a witness may be proved to corroborate the later testimony given in the court during the examination in chief and cross-examination as of the same fact. When you read section 155 and 157, you kindly read it slowly, because every word in the Evidence Act is important. You have to let it go slowly, only then you may be able to understand the true intent and purport of that section. So, in case of statement made by a witness as substantive piece of evidence before the court, can always be corroborated with the former statement made by him. But the question arises when it contradicts the earlier versions. Then that credibility of the witness has to be impeached in terms of section 155 subsection 3 of the Indian Evidence Act. X states in the witness box that Y step Z. Kindly listen carefully. X states in the witness box that Y step Z. So X was making a statement in the dock saying that Y step Z. But before the police, X stated that A step Z. So in the witness box, he says that Y step Z, whereas before the police, he said that before the police, he stated that X stated that A step Z. So instead of Y stepping Z, which he stated before the police, in the court he says that it was A who stepped Z. So this is a pure and simple case of contradictory statement. And if you don't bring out the contradiction during recording of cross-examination of the witness, then you cannot rely on it. So it is very important to read section 145 of the Indian Evidence Act 1872, how a witness has to be contradicted. The text of this section 145 of the Evidence Act says that cross-examination as to previous statement in writing. Here the previous statement was the previous statement which is recorded under 161 CRPC is mostly referred. So section 145 starts by saying the witness may be cross-examination. So the first, a witness may be cross-examination to what? As to previous statement made by him in writing. So when we are dealing with 161 and 162, we have already stated that the investigator authority has the discretion to examine witnesses, and if he decides to rely on the evidence of that witness, he has to reduce it into writing. So any relevant matters in question, if it is without such writing, then that such writing has to be shown to him or being proved. But if it is intended to contradict him by the writing, suppose witness, you want to contradict a witness in the dock. You have seen that during examination in chief, he makes a statement which is different from the statement he gave it to the police. So while cross-examining that particular witness as a defense lawyer for the accused, you can contradict him by showing his writing or that part of the lines which are in contradiction with the statement made before him in court. Attention of the witness has to be drawn to those part of the statement made before the police which contradicts his statement in court. So section 145 of the Evidence Act applies when the same persons make two contradictory statements. So remember carefully that section 145 of the Evidence Act is applicable only when the same person make two contradictory statements, one before the police or say for example one before the court. And while examining contradictions, the court must always keep in mind that it cannot demolish the evidence of one witness by referring to the evidence of other witness. The defense counsel also should remember that he cannot contradict the statement of A and B witnesses to prove a contradiction, because so far contradiction is concerned, it can come into play only in terms of section 145 by showing his previous statement and not to statement of any other witness. What is the object behind section 145 of the Evidence Act? Let us understand in brief. The object of section 145 of the Evidence Act is to give the witness a chance of explaining the discrepancy or inconsistency. So remember carefully, section 145 object is to give the witness a chance of explaining the discrepancy or inconsistency and to clear up the particular point of ambiguity or dispute. And as a lawyer, you should always remember that extracting a contradiction or an omission which amounts to a contradiction is an art of the cross-examination. And the method to prove it is a sign. And any contradiction, if proved in accordance with the provisions of the Evidence Act 1872, can impeach the credibility of the witness, and it can help in presenting the evidence of the prosecution in criminal trials and of the other side in civil trials. So I am repeatedly asserting that contradictions have to be proved in accordance with the procedure established under the Evidence Act 1872. Otherwise, you would have no evidentiary value and would not be admissible. And a witness can be contradicted with his previous statement, either made by him in writing or reduced into writing by someone. And this section 145 essentially allows the opposing party to cross-examine a witness about their prior statement made in writing, even if the written statements are not shown to the witness initially. And I'm just reiterating, kindly remember that if you want to contradict a witness using those prior statements, the specific part of the writing that contradict the witness must be brought to their attention during cross-examination. Say for example, you are given the statement of the witnesses recorded by the police under section 161 CRPC in terms of section 207 and 208 of the CRPC. That means the statements are given free of cost to the accused. You look into the statements of each of the witnesses under the 161 and you find that the statement that is given in the dock during criminal trial, he makes a completely different statement which is not in consonance with his earlier statement. Then that part of the statement which he has made before the police, especially that contradictory statement, must be brought to his notice, and you must request the court to put it under inverted comma. So later on when the IO comes to the court for his examination, you can put that same inverted comma statement to the investigating officer and ask him that whether this statement which you have recorded under 161, whether this has been made by the particular prosecution witness. And if the IO admits yes, then the contradiction is proof. So without putting those statements again to the investigating officer at the end of the examination of the prosecution witnesses, contradiction will not be proved. Simply by showing to the prosecution witness that what you have stated before the police is not in consonance with the statement which you have made in the dock today will not suffice until you put the question to the investigator, the same part of that statement to the investigating officer during trial. And we all know that in criminal trial, statement recorded by the police during the course of any investigation, as I have already discussed in the earlier videos, that it cannot be used for any purpose during trial except to contradict the witness as provided under section 145 of the Evidence Act 1872. While reading section 145 of the Evidence Act, you kindly read section 162 of the Code of Criminal Procedure, because under section 162 of the Code of Criminal Procedure also provide a protection to the accused, because sometimes the overzealous police officer and untruthful witnesses may try to record or to extort statements from the witnesses which is not acceptable or admissible in law. And in some cases we find during trial that a witness either turns hostile or are giving exaggerated testimony. Then that procedure is also provided under section 162 of the CFPC. You kindly look into it, because that the procedure has to be followed, how he has declared hostile and how his evidence can be made admissible in court. Wherever, means during trial, sometimes we find there is very clever witness. They will try, while recording their examination in chief, they will try to confirm what they have stated earlier to the police. But when you cross-examine those witnesses, you will find that these witnesses, in the most subtle way, is even contradicting the effect what they have stated in the examination in chief. So in such a situation, it becomes very important for the defense as well as the prosecution to bring the earlier part of the statement which is inconsistent with the deposition on the record of the case, or otherwise it cannot be used for any purpose and the court will not be in a position to refer to it. Let me also refer to how the hostile witness has to be treated by the public prosecutor if the witness turns hostile. If the witness turns hostile and recede from his earlier statement made before the police, then it is important for the public prosecutor to bring that part of the earlier statement on record of the trial, and the same procedure under section 145 of the Evidence Act has to be followed, read with proviso to 162 of the code. Now, let us try to understand what is an omission. An omission is either skip or slip. It means exclusion or leaving out. Say if a certain fact is testified by a witness in his examination in chief, such fact which is testified in court has been omitted to state before the police. It is called an omission. Now this omission has to be tested by the court, whether it is a material omission or not. If it is a material omission, it amounts to material contradiction. The Honorable Supreme Court had opined that relevant and material omissions amount to vital contradictions, and which can be established by cross-examination and confronting the witness with his previous statement. In respect to omission and contradiction, I would request my viewers to kindly look into the judgment of AR 1959 SC 1012. Kindly note of this judgment. It is Tahsildar Singh versus State of UP, reported in AR 1959, Supreme Court 1012. Tahsildar's case is the Bible on the concept of contradiction and omission. So kindly read each and every paragraph of Tahsildar Singh case to understand omission and contradiction. So remember, a bare omission cannot be a contradiction. In order that omission becomes a contradiction, it must have vital bearing upon the truth of the story given. But the procedure for proving a contradiction and to prove the omission, a slightly different technique has to be applied. In the case of omission of the most vital and relevant aspect, the contradiction is implied and it is not so direct. And unlike in contradiction, in order to confront with the earlier statement, there is nothing in the earlier statement which is contradictory, as the witness may have improved his version during the testimony. So first, the contradiction will have to be brought by asking question in cross-examination, which are permitted under section 162 of the Criminal Procedure Code. So to understand it, let us look into an illustration which has been explained in the landmark case of Tahsildar Singh's case. X makes a statement before the police that when I arrived at the scene, I saw A running away, chased by B and caught by C. In the witness box, X says that when I arrived at the scene, I saw A take out a dagger from his pocket, stab D in his chest and run away. And he was chased by B and caught by C. This is an example of omission of two facts in the statement before the police. Number one, A takes out a dagger from his pocket, which he did not state before the police. Second is A stabbed D in his chest, which he did not state before the police, but he for the first time in the dock during the trial, he makes a statement in this regard before the court. So these omissions are vital. And the court has observed that it is not believable that the witness who says A took out a dagger and stabbed D in the chest would not mention such a crucial and important fact to the police. Further, the court also observed that it is not possible that a police officer who investigated the case would miss out on such a crucial piece of information. So the implication would be that it can be implied that the witness has improved his version and is not giving out the correct facts, and therefore the omission becomes a contradiction. However, in order to bring the contradiction on record, first the omission will have to be converted into a contradiction by asking the question in the cross-examination, which will bring out the contradiction. We must remember that the cross-examination in the case of omission becomes very important, and it should be aimed at bringing out the contradiction between the statements. To conclude, kindly remember that the importance of proving contradiction in accordance with the manner prescribed under Section 145 of the Evidence Act is absolutely important, and it's very crucial for any practicing lawyer in the trial courts. And if contradiction are proved as per the procedure, then it can have a considerable impact on the trial, because the contradictions and the omissions which are contradiction cannot be relied by the court. However, you should remember that cross-examination may vary from case to case and on the facts and circumstances, as well as different counsels may adopt different technique for cross-examination in regard to previous statement. First, when you want to prove a contradiction, first look into the statement which is recorded under 161 CRPC or 164 CRPC. And you find that during examination in chief, during trial, you find that particular witness is trying to improve upon his statement made before the police when his statement was recorded, or he is trying to introduce new facts which are not there in the earlier statement under 161. In the traditional method, we would we'll draw the attention of the witness to that 161 statement and show to him that this is the statement which you have stated today in the examination in chief. You have not made it before the police, and we'll request the court to mark it up. That means to put it under inverted commas, so that when the investigating officer later on appears to the court, we have to put him that marked portion again to ask him that whether this was said by the witness. Only if he said that yes, it was said by the witness, then the contradiction is proved. And in case of omission, all omissions are not material. The omission which have serious impact or which are which is relevant, and it is not believable that the witness can omit to say such facts, or the investigating officer omits to record such a vital piece of evidence, then omission can also be a contradiction. So as we conclude this session, we encourage you to explore more about contradictions and omissions. There are numerous judgments of the Supreme Court in this regard. I do not want you to burden today with the citations of all these case laws. Maybe in a separate video, when we discuss the leading case laws on contradictions and omission, I'll bring it before you. But I have referred to the Pathshala's case. Pathshala's case, kindly read it. It is considered as a Bible of on the topic of contradictions and omission. So tune to Nyay Pathshala, and we always expect you to remain dedicated to our channel as we provide valuable insights and knowledge to aid your journey in the field of law. Thank you for being part of our learning community, and we look further to enrich your legal education in the future. Lastly, I will request, as always, kindly do subscribe to our channel who have already not done, and hit the bell icon for future notification.